Right. Hello, everybody. A very good evening to all of you who are joining us, both panelists as well as the members of the audience. On behalf of the Bar Association of Sri Lanka, it is my pride and pleasure to welcome all of you on board this Saturday evening. At a time where all of us are socially distanced, it is indeed a privilege to be able to gather online and get together virtually from all parts of the island, from the north, the south, the east, and the west. As overseas, we have viewers joining us for these webinar series. So we welcome you all to the 48th webinar of the first series of webinars. And all of this is only possible owing to the effort and the dedication of the seminars committee as well as the management committee of the Bar Association of Sri Lanka. So we thank them, and we all thank all our viewers who are joining us today as well. Today too, we have an interesting topic, and today we will be discussing negotiation and execution of construction contracts. That will be the topic of today's webinar. And this, of course, is an important and an interesting area in a fast changing and developing day and age. So I hope all of you make use of it. To enlighten you on this topic and discuss the legal as well as the practical aspects of things, we have a fabulous panel of experts. It is my privilege and pleasure to welcome today's resource persons on board. Let me introduce them to you all. Right, first and foremost, we have with us Mr. Chanaka De Silva, President's Counsel. Mr. De Silva commenced his legal career as a state counsel in the Attorney General's Department in the year 1987. He is a partner at Nithya Partners and leads the firm in handling specialized litigation. His areas of practice are litigation, alternate dispute resolution, projects and project financing transactions, construction, labor law, customs law, intellectual property law, privatizations, and regulatory and compliance matters. For over 30 years, Mr. De Silva has been involved in advising, negotiating, and structuring major infrastructure projects in Sri Lanka, advising the Sri Lanka government, and also many other multinational companies. He has also been involved in formulating legislature as an expert of the field. We also have with us Mr. Jeremy Witt. Mr. Witt is a partner in the Energy Projects and Construction team and is based in Australia and has an extensive experience acting on complex and distressed projects. He advises on contentious and non-contentious construction, energy and infrastructure matters, and has experience with major standard forms of contract. Mr. Witt regularly advises on all types of dispute resolution, specializing in international arbitration. We welcome you on board. We also have with us Mr. Rajendra Jayasinghe. He took oath as an attorney at law in 1997. His work is predominantly in the areas of commercial and corporate law, commercial litigation, mergers and acquisition, company restructuring, construction and engineering contracts, banking, investments, and insurance. He is also a management accountant with experience in business consultancy and corporate taxation. His experience in accountancy has given him practical insights into strategizing commercial transactions and formulating business agreements. We welcome you on board. We also have with us Mr. David Wright. He is a senior associate in our infrastructure and construction practice, specializing in complex, high-value disputes on projects across the globe. Mr. Wright has advised clients, including governments and some of the world's largest contractors, on disputes relating to key projects such as international airports, coal-firing power plants, hydroelectric dams, and oil production facilities. Mr. Wright has advised clients on various methods of dispute resolution, including litigation, adjudication, mediation, dispute boards, and international arbitration. We welcome you on board. Next, we move on to the moderator of the day, that is Mr. Dushantha Pereira. Mr. Dushantha Pereira is an attorney at law and he is a partner and head of the Corporate and Commercial Law Department at Sudat Pereira Associates. So without further ado, I now hand over the proceedings to the moderator of our day. I hope all of you have an interesting and a fruitful session. Over to you, Mr. Pereira.
Thank you, Uma, for that introduction, and thank you to the Bar Association for organizing this webinar. I think I speak for all when I say that the webinar series has been extremely well received by the legal community in Sri Lanka and is rendering a valuable service in providing experts insights and training, both of an academic as well as practical nature on pertinent legal topics. As Uma has already introduced our distinguished panel of local and international lawyers, I will take a brief moment to explain today's topic and the rationale for choosing it, as well as the manner in which this webinar will progress. The negotiation and execution of construction contracts is a very, very wide topic. Construction contracts can range from low-value residential property buildings, for example, between a single contractor and a plot owner, to contracts for the designing and building of high-value commercial towers, known as high-rise buildings, and multi-contractor infrastructure developments, such as roads, bridges, ports, involving multiple contractors coming together as joint ventures or consortiums. The importance of the construction industry to the Sri Lankan economy cannot be overstated. The industry presently contributes to over 5% of the country's GDP, reaching a high of almost 10% in 2014. In recent years, as most of you would have seen, there's been a massive growth in the number of residential and commercial condominiums, hotels and resorts, and commercial properties, shopping malls, office complexes, and other developments being carried out not only in Colombo, but in other cities like Kandy, Jaffna, Negombo, and Galle. And such work is continuing even during the pandemic. With the enactment of the Port City Law, a substantial amount of development is expected in the Port City area of authority over the next 5 to 10 years as well. There are over 2,500 construction companies that are registered with CEDA, the Construction Industry Development Authority. There is, however, a misconception that there is a limited role for lawyers in advising on construction contracts, and that it is primarily in the hands of engineers, accountants, and architects. Nothing could be further from the truth. Whilst the technical and financial matters are largely handled by other professionals, lawyers play an important end-to-end role in helping draft or review such contracts, whether from the perspective of contractors, developers, or financiers, analyzing or advising in analyzing clauses, including rights and obligations during disagreements or disputes, and in seeking resolution through mediation, arbitration, or litigation. Contracts can be simple, bespoke written agreements or complex ones based on a myriad of standardized forms available in the market, ranging from the CEDA ICTAD prepared standard bidding forms, which are commonly used for domestic products, or the international FIDIC suite of contracts. Lawyers are and should be an integral component of the drafting exercise for such construction contracts, in addition to being called upon to assist parties in a dispute. If you look internationally, there are international lawyers who specialize in advising on construction contracts and building practices around construction law matters. In fact, a lot of the larger international firms have multi-jurisdictional construction law practice groups dedicated to handling such areas. One such firm is CMS, and we have 2 experts from the firm with us today as panelists. There is huge potential for Sri Lankan lawyers themselves to build specialist practices in this area, especially at a time when the pandemic has adversely affected traditional areas such as litigation. We'll be kicking off today's proceedings with an introduction to construction law contracts and an overview of the provisions that are ordinarily included or seen in such agreements from Senior Attorney at Law Rajendra Jayasinghe. Thereafter, we will have David Wright, Senior Associate from CMS, speaking on the subtopic of COVID-19, successful execution of a project during a pandemic. And afterwards, Jeremy Reed, who is partner CMS, on variations successfully managing change. We will subsequently wrap up the panel discussion part of this webinar with insights and an experience sharing session from President's Counsel Shanaka De Silva. Finally, we will have a brief Q&A where you, the audience, can raise any questions you have on the topics under discussion to the panelists. So without further delay, let me hand over to our first panelist. Rajendra, the floor is yours.
Thank you, Dushanta, for the introduction, and Maya for the lovely introduction of the speakers. Okay, Dushanta, can you see my screen?
Not yet, Rajendra.
Not yet, okay. Let me just a minute. Okay, can you see the screen?
Yes, we can. Thank you.
Okay, great. So as Tushanta said, my job today is to give a basic overview of the construction contract so that the other panelists can go into more specific details. The construction industry in Sri Lanka is regulated by the Construction Industry Development Authority, known as SIDA. So all the contractors and qualified consultants who are engaged in identified construction work have to be registered with SIDA. And so the industry is pretty regulated under the SIDA Act. And even foreign consultants and foreign contractors have to get temporary registration with SIDA in order to engage in identified construction work. And identified construction work is basically work exceeding rupees 10 million, which consists facilities and amenities for the public use, and construction work which requires the approval of environmental, geological, and cultural heritage regulatory bodies. Private residential buildings constructed for the use of any private owner is excluded. SIDA also has a form of contract which we call the standard bidding documents and or the SBDs and specifications which have to be used for work which relate to identified construction work. It also has a dispute resolution mechanism and can be used if your contract does not provide for one. So who are the parties to a building contract? Basically, it's the employer and the contractor. Employer is the person for whose benefit the construction work is carried out. That is, for example, if it's a building, it's the owner of the land who's putting up the building. And the other part is the contractor, that is the builder that carries out the construction work for the employer. All and the contractor that are the parties to the contract, there are several other people involved whose work will affect the legal relationship between the employer and the contractor. So these other parties, broadly speaking, could be termed as the architect or the engineer. An architect is the person, architect or an engineer is the person employed by the employer to carry out the plans, specifications, supervise the execution of the work on behalf of the employer. Then you get the quantity surveyor, or who we call the QS. QS is also employed on behalf of the employer, and the QS does the estimate of quantities for the proposed work, and he prepares what is called the bill of quantities. The bill of quantities gives the rates and the quantum of work to be performed and the pricing. And then the QS also can get involved if there are any variations, which I will talk to what variations are later, to measure and value variations. Then in bigger projects, sometimes you get, in larger projects, there are consultants for specific areas. So you can get structural engineers, mechanical and electrical engineers, so on and so forth. They are called consultants. They perform a specific task and for specific areas. Then there's also the project manager, who does more of an organizational role, who coordinates between the people and the work on behalf of the employer, and even a contractor sometimes in large projects has a project manager to look after the work of the contractor. Then some projects can have subcontractors, where the contractor frequently subcontracts part of the work to a subcontractor. And sometimes the agreement or the architect names a subcontractor, and they are called nominated subcontractors. Then you get sureties. Sureties would ordinarily be banks or insurance companies which guarantee the work, maybe the performance of the contractor by giving a performance guarantee or a performance bond, and then also guarantees the advance payment by issuing advance payment bonds. Then what are the contract documents? Now, basically, in a building contract has all the elements of general contract law. When I mean all the elements, it has an offer, acceptance, consideration, performance, that which we are familiar with. But the contract, in building contracts or construction contracts, it's a field of its own, and the contracts are very specific and very detailed. So for example, CEDA provides standard bidding documents, and that is divided into standard bidding documents for major contracts, minor contracts, design and build contracts. Then it gives specifications for maybe electricity supply, water supply, storage, so on and so forth. Then if you look at it, look at internationally, there is something called FIDIC contracts, which Dushyanta spoke about. And FIDIC contracts are issued by the International Federation of Consulting Engineers, and it's the gold standard for contracts. The standard bidding documents and FIDIC use a balanced approach to the roles and responsibilities of the main parties, as well as allocation and management of risk. So in other words, it's drafted in a very fair manner, and it is fair by the employer, fair by the contractor. And it's very time driven. What I mean by time driven is there's a time for everything. Like, for example, once you submit your work, there's a time limit given for the engineer to certify it. There's a time limit given to the employer to pay for it. Then if you are disputing, there's a time limit to raise that dispute. So it tries to avoid vagueness and tries to get the project completed without unwanted disputes. Then the other peculiarity of a construction contract is so many documents form part and parcel of the contract. Unlike in a normal business agreement, it might be one agreement with a couple of annexures. But here, several documents form part and parcel of the contract. And in most documents, there is an order of priority when it comes to interpretation. Because if there are, as you know, when there are several documents, it can give rise to which document is valid if there is a conflict in certain clauses. So, as an example, so what you have to remember is there might be a priority of documents. And as an example of some of the documents forming the contract, I've set out there are contract agreements, the letter of acceptance, letter of tender, so on and so forth. I'll just say that under FIDIC and both STB, there are general conditions of contract which set out for most eventualities are covered by that. Then there are particular conditions of contract which are specific to the contract at hand, because no two contracts are the same. So it is in the particular conditions of contract that a lawyer has a role to play, because he can understand the concerns of his clients, ascertain what sort of disputes which might arise, and adjust those agreements at the inception, or adjust those clauses at the inception by inserting them into the particular conditions of contract. Then you get the appendix to general contract basically that would set out the time limit, the amount of the performance guarantee, amount of the advance payment. Then I also spoke about sureties, because banks provide now the contractor, when the contract starts, has to give an advance payment. The employer gives an advance payment to the contractor, and that is secured by an advance payment guarantee or advance payment bond. And the performance of the work is also secured by the performance payment, performance bond or a performance guarantee. Then, just to explain to you briefly the traditional process or the operation of a contract. Basically, the employer will engage an architect or an engineer and a QS. The architect will draw up the plans, and the QS will measure the amount of work and material necessary to complete the work and prepare a bill of quantities. Then they will obtain all the necessary regulatory approvals, the municipal approvals, and then prepare a form of tender or a tender document which will be sent out to contractors to bid for the tender. So generally a tender document would constitute the bill of quantities, plans, the specifications, the proposed conditions of contract will be sent. Then the contractors will submit their estimates, and thereafter the engineer and the architect will help the employer to select a particular contractor, and a letter of acceptance is drawn by the employer, who will give it to the contractor. And once the contractor accepts a letter of acceptance, the particular conditions of contract will be drawn up, parties will sign the contract, and the contractor will be required to provide an advance payment bond, upon which an advance payment will be released for the contractor to commence work. And similarly, the contractor will have to also provide a performance bond guaranteeing performance of the work. Thereafter, work commences, and the work is supervised on behalf of the employer by the architect or the engineer. Then with regard to payments, these contracts take a long period of time, so the contractor cannot wait until the end of the project to receive all the payments. So there are stages at which after a part of the work is completed, the contractor raises an interim payment bill where the work is supervised by or examined by the architect and the engineer, and the bill is certified. Once the work is certified, work will be paid, the money will be paid for that interim bill. Thereafter, after several interim bills, when the work is completed, the final bill is submitted, and the architect will go through the work, measure the work, and recommend what the final amount to be paid is. So what, in most cases, the final amount to be paid is different from the original contract price. There are several reasons. There might be variations of the work. Then there might be price escalations. Then there may be damages, liquidated damages deducted from the contractor for delays in the work. So for several reasons, the price may differ. Then if at that stage or at an earlier stage, if there's a dispute or if the parties cannot agree on the price, then the parties will have to resort to the dispute resolution mechanism provided for in the agreement. Generally, in the standard bidding documents of CEDA or FIDIC, there is a multi-tier dispute resolution process. What I mean by multi-tier dispute resolution process is they attempt to resolve the dispute amicably. So there is something called a dispute adjudication board. Then if that dispute doesn't get resolved there, the parties will try to amicably resolve it, failing which they will refer to arbitration as provided in the agreement. Now I will briefly talk about variations. A variation is a change to the original scope of work. I'm talking about variations because the other panelists will go deeper into it. So there is the original scope of work for which the contract is entered into, and then there can be a variation. For example, let's say you enter into an agreement for a 10-story apartment complex, but subsequently the employer wants another floor added, or he wants certain work deducted. So that's a variation. For variation to take place, the architect has to issue a variation order. The contractor has to provide the cost of such variation, that has to be approved, and it is only thereafter that the variation work will take place. If such variation order is not issued and the work is not approved, he will not get paid for the variation. Then there is something called extension of time, where the contract is entered into a certain period of time, but due to different reasons, the parties have to, the contractors to seek an extension of time. For example, the best example now is due to lockdowns due to pandemic. Then there can be inclement weather. There can be shortage of material. There can be injunctions from the neighbors. So all those extensions of time have to be approved by the parties, approved by the engineer. And if not, the contractor will be liable to pay liquidated damages. What are liquidated damages? Liquidated damages are damages agreed or fixed by the parties for breach of contract. So for example, the contract will say, if you delay work, if the contractor delays work for each day of delay or each week of delay, you will be liable to rupees X amount as liquidated damages. Then I will just get into some briefly some practical aspects with regard to the documentation, correspondence and claims management. It is essential that extension, for example, extensions of time, variation order, all those things, the contractor has to write immediately. The contractor cannot wait until the end of project and seek extension of time. So if, as a practicing lawyer, you have to advise your client to seek, you have to correspond immediately, maintain the documentations and correspondence in a way where if there is a claim, you have easy access to it, and also have a claims manager to advise you on that. Then I think, Dushyant, I'm sort of at the end of my time, and if there is anything further, I can go further during the question time. Thank you, Dushyant. That's all from me.
Thank you, Rajendra, for that very, very comprehensive overview, which provides, I think, a very excellent foundation into construction contracts and sets the stage for the next panelist as well. So firstly, I would like to call on Mr. Jeremy Witt, Partner CMS, to give a brief introduction to CMS, and then hand over to David Wright, Senior Associate, to present on his topic, COVID-19 successful execution of a project.
As Rajendra's excellent overview highlighted, there are many different issues that can arise from the negotiation and execution of a construction contract. Today, we're hoping to give you some insight from our experience on two of the key issues we encounter and how best to advise your clients to navigate these issues. As Jeremy said, I'll start off with the first section, which is on COVID-19, understanding entitlements in a pandemic, before Jeremy takes us through variations and how to manage change. Of course, we intend for this to be a discussion if possible. So if any fellow panelists want to chip in, of course, please do. COVID-19 then needs absolutely no introduction. The impact of the global pandemic's been felt in every facet of life, and construction projects are absolutely no different. When you think of construction projects, be they local or international in nature, they'll often involve global supply chains, a significant labor force, stringent health and safety requirements, all of which are vulnerable to and impacted by the pandemic and its effects. Some projects, as we all know, have had to stop completely, and others have faced significant delay and disruption. This is put to test the advisors of contractors and owners to advise on how best to manage delays, disruption, and stoppages under the standard form contracts that are in use. Many of the projects that we deal with working internationally use the FIDIC form, which has already been introduced to you. And the Sri Lanka SPD Form 2, which I'll refer to a couple of times in my presentation, is based largely on the FIDIC form. There's a lot of similarities there. We've identified some key clauses that we think practitioners should be aware of when advising clients in the construction space on issues arising from the pandemic. Firstly, when we talk about entitlements under construction contract, certainly from the perspective of the contractor, we're really talking about time, meaning an extension of time for the completion of the project and the additional costs incurred in overcoming any issues that arise. So time and cost are the basic entitlements. In the context of a pandemic, issues may be, for example, a lack of manpower due to border closures causing delay to the project, increased costs from requirements to provide workers with protective equipment, lack of availability from manufacturers of equipment. The list really goes on and on. In our experience, when issues such as these are encountered on the project, the first port of call for contractors, owners, lawyers, anybody with an interest in the contract and the project is the force majeure provisions. For reference, for those of you looking at the Sri Lanka SPD, that's a 20.1. An event of force majeure there is defined as an exceptional event or circumstance beyond the party's control, which could not be reasonably provided for in the contract, could not be avoided or overcome, and which is attributable to neither party. It's easy to imagine, obviously, how a global pandemic could fall into this definition. It's also noteworthy there's a list of specific force majeure events provided in the SPD and indeed in FIDIC. And this doesn't include pandemic or anything really that similar. And it might be difficult to argue that COVID-19 is a natural catastrophe because that specific example refers to earthquake, hurricane, typhoon, or volcanic activity. Although I have seen in my experience contractors try to argue that COVID-19 is a natural catastrophe with various degrees of success. However, even though it's not specifically mentioned in this list, all is not lost because it's not an exhaustive list. And provided the requirements I first mentioned can be fulfilled, i.e. unforeseen, beyond the party's control, etc., then COVID-19 may indeed qualify as an event of force majeure under your contract. What does that mean? Great, it's an event of force majeure. Well, if the contractor is being prevented from performing its contractual obligations by the event of force majeure, then provided the correct notices have been provided, as Rajinda mentioned, and I'll mention a little bit later, that's very important, the contractor is potentially entitled to an extension of time. Cost under the SPD is also recoverable, but only if the force majeure event is one of those specifically listed, which are war, riot, natural catastrophe. So not necessarily COVID-19, and it may be difficult to recover costs in that example. It's also worth keeping in mind that if an event of force majeure is continuing, so it's an ongoing impact on the project, I think the SPD refers to it being 84 days or a total of 140 cumulatively, then the parties have the right to terminate the contract. So that's something to keep in mind, even though cost isn't necessarily easy to recover under the force majeure provisions. If, as a last resort, parties are looking at termination, force majeure is something to keep in mind. Another option which we see regularly, which probably provides a more direct route, certainly, to recovery of costs for the contractor, is adjustment for changes in legislation. You find that in the SPD at 13.6. It allows for an increase in the contract price resulting from a change in law in Sri Lanka during the period 28 days prior to the closing date of bids and ending on certification of completion or on termination. Why are we talking about a change of law in relation to COVID-19? It seems like it's a force majeure event. In our experience, delays and disruption actually caused to construction projects is often as a result of new laws being introduced by state, local governments to attempt to stop the spread of the disease, such as introducing social distancing measures, closing borders, banning workers from certain countries working on site, things like that. Remember, the SPD also expressly provides that the contractor must comply with all applicable laws, which are defined very, very widely, meaning all legislation, statutes, ordinances, regulation, and bylaws issued by a legally constituted authority. Not only are laws defined widely, but a change in law also means an enactment of a new law, a change in existing legislation, repeal or modification of existing laws, or change in the judicial interpretation of those laws. So there really is wide scope. If your project is being hindered or impacted in really any way by change of law or the change interpretation of a law, there's wide scope to be able to seek recourse under the change in law's provision, the adjustment for changes. If the project is impacted by change in laws intended to stop the spread of COVID, the contractor has an avenue to claim both an extension of time to completion of the project and cost. One key point to note is that FIDIC, as well as the SPD, that change in law must occur in Sri Lanka. And if we're talking about Sri Lankan projects, this means that, for example, if there's a change in law in China, that means your equipment that you're looking to get in is delayed for whatever reason, that's not going to be an avenue for you because the change in law hasn't occurred in Sri Lanka. It's happened in China. There's a few other clauses to keep in mind, and in the time we have allotted, I can't run through all of them in detail, but it is worth making you aware of them. There's clause 8.5, which allows for an extension of time if the contractor encounters delays as a result of procedures from public authority, which are unforeseen, and 8.9, which allows for an extension of time as well as cost if the engineer instructs a suspension of the works, which you can imagine it may well do if the project's impacted by COVID-19. It's important as well as understanding where the potential avenues for entitlements to time and cost arise for our clients. It's also important that we're able to advise it's not simply enough to point to a clause and expect time and cost to automatically flow. It's important to analyze the specific facts surrounding the delay or disruption and to understand what the actual cause is. Keep in mind any applicable Sri Lankan laws that may impact that as well. Keep rigorous records showing the day-to-day impact of the event or the project, and keep communication lines open with all of the other parties that Regina mentioned, and try to agree a practical way forward where possible. Remember, a construction project runs best when collaboration between the parties is the first recourse to resolving any issues. So before necessarily any of the contractual mechanism engaged, often a conversation is a very good starting point. Again, as Virginia helpfully referred to, I can't stress enough the importance of providing notices required by the various clauses of the contract. One of our key jobs at CMS that Jeremy and I both have done is we'll act as project counsel, so we'll be taken on at the very inception of a project and revised throughout the life of the project. And one of the key jobs in that role is making sure that notices go in on time, the content is right, and the form is right to protect any entitlements under the contract. I mentioned execution there, and in terms of actual execution and contract admin through a pandemic, FIDIC and the SPD also provide for various actions that must be taken. I put some of them on the slides here. Particular importance, monthly progress reporting. So keeping the owner up to date with what the actual progress and the grind of the project is. Often this is monthly project reports, which set out any impacts on the time to completion of the project, or really any issues that are occurring. The program by which the contractor intends to complete the project, how they're going to get it done. That should be updated regularly to reflect actual progress. As I've mentioned before, notifying any events that happen, should get that letter in to the employer as soon as possible, certainly within the time allowed. A duty also to use all reasonable endeavors to minimize delay. So it's not enough just to say, I'm impacted by this change of law. Contractors should be taking proactive steps to try and move the project along as best as possible. The entitlements I've mentioned are great if you're already signed a contract and the project's underway. However, if you're about to sign a contract and commence a project, it can hardly be said that COVID-19 was unforeseen under the force majeure provisions, and any change in laws that would have an impact on the project might have already occurred prior to signing the project and prior to bidding even, which means a claim under the change of law provisions would also have issues. How are parties getting around that? Well, in our experience, parties are considering specific clauses to address the pandemic when they're negotiating a contract. Because even though it's not necessarily unforeseen, the impact on the project is far from certain as the global and local position changes regularly with new outbreaks and variants seemingly occurring daily. There's no real standard clause that we've seen, but one option that we have seen, and I'll put it on the screen here, is to introduce a specific definition of a pandemic event, which refers to it occurring before or after the date of the contract, and includes not only the pandemic and its mutations, but measures introduced by governments in relation to the pandemic, and also lists several consequences. There's then a specific entitlement to time and cost that can be introduced as well. So even though the pandemic may not be an unforeseen event when you're entering into the contract, during negotiations, parties should, at the very least, before entering into the contract, be thinking about how they're going to deal with the relative unknown that's a global pandemic, how they're going to ensure the project is delivered on time and to the required high standard. This has obviously been a very, very high level introduction given the time we have, but I'd encourage those dealing with these issues or are interested at all in becoming more engaged with these issues to get onto the FIDIC website and download and read the guides that they've published in COVID-19. There's several guides on the application to clauses, which I've discussed, setting up various scenarios, which are a real help to practitioners trying to understand how the contract is intended to operate. Obviously, it's by FIDIC and it's referring to the FIDIC form. But as I said, the SPD is based in FIDIC. So I think you're going to find some really useful information there, as well as practical guides on on-site working and for global engineering businesses as the pandemic continues. I'll hand over to Jeremy now. That's my run through on COVID. Thank you so much for listening.
Thanks very much for that, David. And yes, as David mentioned, it's very much a privilege for us to be here with you all today, and we're very grateful for that, particularly to be able to present with such an esteemed panel. David, if I could get the next slide, please. Thanks. So why are variations important? Probably the key reason is it preserves the contract but allows changes. Changes are a fact of large-scale construction contracts. It's very rare. As a matter of fact, I can't think of any large-scale construction project I've ever been involved in, either as a contractor or as a lawyer, where there haven't been a significant number of variations. I was a contractor for over a decade before I became a lawyer and worked on a number of projects. So I do wear, I suppose, both hats in different ways at times. But in terms of variations, it's just something which would be unheard of to have a large project without variations in my experience, or at least without variation claims. Employers need to have a variation clause because it gives them the flexibility to make changes. If you don't have a variation provision, then there is no power at general law under most governing laws to simply order a contractor to do additional work outside the scope of the contract. And the effect of that, of course, is the contractor could then simply refuse to do the additional work, and the contractor could effectively hold the employer to ransom, and the employer may end up with a project which doesn't do what it wants it to do, or need to spend a very significant sum of money either then or down the line to have that done. It also allows for an employer to have more work carried out than previously agreed, and it can be done at the same or similar prices, particularly with a appropriately drafted variations mechanism. And it ensures, finally, that the contract won't become frustrated if it's impossible to carry out the previously agreed work, because there's been some fundamental change, which means what the parties had agreed to is just no longer workable. Can we have the next slide, please, David? So looking at the SPD2, it specifically provides that changes by way of variation may include changes to quantities of any item included in a contract, although those don't necessarily constitute a variation, changes to quality and other characteristics, changes to the levels, positions, and dimensions of any part of the works, omission of any work unless it's to be carried out by others, which is an important caveat to have there, additional work, plant materials, or services necessary for the permanent works, including testing, boreholes, exploratory work, and could also involve changes to the sequence or timing of the execution of the works. So for instance, if the employer via the engineer instructs the contractor to do the work in a different order to facilitate work by other contractors or subcontractors, that may well amount to a variation. Can we have the next slide, please, David? Omissions. So as David mentioned, the SPD form is very similar to the FIDIC form, specifically the 1992 Rainbow Suite. The FIDIC 99 forms provides that a variation shall not comprise the omission of any work which is to be carried out by others. And the effect of that is the employer cannot simply select the most favorable bidder it receives on a project, sign them up to a contract, and then subsequently find a cheaper contractor or subcontractor for an element of the works, delete that part of the works, and have it completed by someone else. If they did so, that would be a breach of the contract, and the contractor would then be entitled to sue for the loss and damage they suffered, which would be typically the loss of profit, which they would have expected to have made. SPD2 has similar protection for contractors, where it provides that the omission of work may form part of a variation, but not if it is to be carried out by others. So I think the key there is this is a really important provision for employers to have, because they may need to reduce the scope of the work. There can be any number of reasons for that, a change of plans, or even just simple financial constraints that they can't afford to have all of the work done at that point in time. But equally, from a contractor's perspective, it's quite important to ensure that they are protected and that the work cannot simply be taken away from them and given away to others. And I will say that having worked on a number of FIDIC-based contracts in the Middle East and Africa in my decade in the region, it was fairly common to see the employers try to change that provision to entitle them to take work away and give it to others. which is not really within the spirit of the FIDIC form. But if the contractor was prepared to sign up to it, then they would have to deal with the consequences of that. Can we get the next slide, please? Variations, a common cause of disputes. I think it's fair to say that it's probably in the top 2 or 3 causes of disputes in my experience dealing with construction disputes over the years. And some key pitfalls or things to consider we've got listed on the slides here. So does the contract allow the employer, its agents, or employees to instruct variations of the work? And this is something you really need to consider very carefully when you are signing up to a construction contract. No matter whether you are the employer or the contractor, it's who can actually instruct the variation. Otherwise, from an employer perspective, you can find yourself in a position where the contractor justifiably refuses to do a variation, or you find yourself in a position as a contractor where you can do a variation thinking it's been validly instructed, because, for instance, you were told by a project manager to go ahead and do some additional work. But if the contract expressly provides that the variation can only be instructed by the engineer, the contractor could find themselves in a position then where they're not entitled to receive any additional remuneration. So that's certainly something they need to be cognizant of. Was the person who ordered the work authorized by the employer to do so? That's obviously an extension of that, but can also lead to disputes. And those aren't disputes simply then at the employer-contractor level. From the employer's perspective, that could also lead to disputes between the employer and their engineer. If the engineer has gone off and issued instructions which it was not entitled to under its consultancy appointment, that can lead to disputes there as well. Whether the work instructed is already included in the contract is probably the leading cause of disputes on variations in my experience. There's often a great deal of disagreement about what is included in the scope of the works. And I think Rajendra hit the nail on the head here, and I think Dushyanta did too, in terms of the work that lawyers can do for their clients and the value that we can add for our clients in the negotiation phase. Yes, the majority of us are lawyers and are not also qualified as engineers or architects or QSs. Some construction lawyers are. But it's very important to ensure that the scope of the contract is really nailed down in the contract. And sometimes that will involve sitting there with the technical people from your client's side and going through in very excruciating detail with them all of the documents to ensure that as much detail as possible is included, so that you minimize the chance of someone arguing about whether a particular element of the works is included or is a variation. Can an instruction be given for work to be deleted or omitted? As discussed previously, those provisions aren't always in the contract. Sometimes they are, sometimes they're not. Certainly, in my opinion, it's better to have a provision which says whether you can do so, and if so, whether or not it can be given to another party, because if not, that kind of ambiguity will lead to disputes. Is the contractor entitled to be paid for a variation? That might seem like an odd proposition, but the simple fact is you're not always going to be entitled to remuneration for a variation. That depends on the mechanism for how variations are to be valued. And indeed, if you are deleting work, then quite often you wouldn't be entitled to payment because it would often lead to a reduction in the contract price. Have the parties complied with notice provisions or conditions precedent to payment? This is a real stumbling block. It's something David touched on as well. Notices in contracts often trip time bars, which if not complied with, will have a contractual mechanism which purports to bar the entitlement. Now, whether that works under the governing law of the jurisdiction, that's another argument. Under a lot of the civil codes that are used in the Middle East, there are arguments that time bars may not always be enforceable, whereas under English common law, Australian common law, Singaporean common law, those time bars will quite often, almost always actually, be enforceable. And I'll defer to my Sri Lankan colleagues as to the position under Sri Lankan law. How is a variation to be valued? Really important, because if you don't have that mechanism in the contract and the parties can't agree, you may end up having to go ahead and perform the work as a contractor. You may be contractually obliged to do so, but you may not actually get any money for it until you come out the tail end of the contract and have completed adjudication or arbitration and determined what your entitlements will be. Whether an instruction constitutes a variation, again, that's a matter of construction of the contract and what instruction is actually given. But the more detail that's given in the variations mechanism about what an instruction needs to be to constitute an instruction, and ensuring that that's given in writing, that's quite important. And finally, non-responsive engineer. Many contractors complain of these problems where they put in requests for variations and they put in paperwork and it's simply ignored by the engineer. You can't always force an engineer to engage, but at least if the contractor has put the paperwork in, then they've put themselves in a position where they have a foundation for claim and a lawsuit if that's necessary. Can we move to the next slide, please, David? Avoiding issues from the outset. So as mentioned, when drafting the contract, ensure there is a clear mechanism and procedure for the instruction of variations. Oral instructions for variations are a real pitfall. So you want to see something in the contract which requires it to be given in writing. There will usually be exceptions to that, such as when it's necessary to protect the project, to protect property, or for the protection of life. And that's not unreasonable. But again, in those circumstances, you would normally have a further caveat which requires that such instructions to be confirmed in writing within a period of, say, 1, 2, or 3 days. And equally, you would want to see a mechanism, if you're from the contractor side, where if an oral variation is instructed, and it's not in one of those circumstances, you're either not obligated to comply, or you can confirm it back in writing to the engineer and then proceed. You will still end up in disputes at times about what the actual instruction was and whether it amounts to a variation, but having that paper trail in place is of critical importance. And it's particularly critically important when you consider the scale of large-scale construction projects and the amount of money involved. Variations can easily run into hundreds of thousands or millions of dollars on large projects. So we are dealing with very significant sums of money, and it can have a very significant impact on clients' bottom line. So minimize the potential for variations by carrying out thorough investigations and surveys of the site and investigating the actual work scope, identifying risks as proactively as possible, and that applies equally for both the employer and for the contractor. Ensure the design is as coordinated and developed as possible when you are dealing with a construct-only project, or if it's a design and construct contract, ensure that the employer's requirements are as clear and detailed as possible so that you minimize the risk of arguing about it. In terms of developed designs, another really frequent cause of disputes arising out of variation claims is whether or not comments that have been issued through a design and the changes made in that manner by the employer or its engineer, whether they actually amount to a variation or that they're a normal part of the design development process, particularly on D&C contracts. That can lead to some very big disputes. So again, it really highlights the importance of sitting down at the outset with your client, helping them and their technical team and the commercial team when the contract is being negotiated, and really grilling the engineers, the architects, their technical people, to ensure that what is stated in the employer's requirements or the technical specifications, that is really detailed, and that they are prepared to sign off on that they understand precisely what needs to be built, and that objectively, if this comes before an arbitration tribunal or a judge in 5 years' time, it's going to be relatively easy to evidence what was required. Now, obviously, many times it's not going to be, but the point is to try to minimize that ambiguity as much as possible. And finally, make clear rates or methodology for valuing the additional work. It's quite common to have rates, whether they're day work rates or unit prices for various kinds of work set out in a contract, and then to apply that for variations. That won't always apply. Sometimes you will have a variation instructed which so fundamentally changes the scale of the work involved that the rates which had previously been quoted no longer work. So if you're talking about doing removal of earth or spoil, and you're initially looking at dealing with 50,000 cubic meters, and all of a sudden it becomes 2 million cubic meters, the economies of scale and the cost of disposal will often be such that the rates which had initially been quoted will not work, or indeed the method of disposal that had been planned to be used will no longer work, because they may have been planning to use it, for instance, as fill, the contractor, and avoiding imported fill, for instance, with a roads project. And now that they need to get rid of a significantly greater volume, they'll need to move it off-site, and that can have a very significant impact on costs. So, the rates and methodology need to be clear, but equally, it needs to provide flexibility for where the work which is instructed fundamentally changes the work which was previously intended to be done, or the scale of it changes so significantly. Can we get the next slide, please, David? Okay, so just a quick slide, and the next one. So that's my details and David's details. Obviously, very happy to help anyone with any issues they have. If anyone needs to reach out to us, happy to discuss things with them. But now I will hand back to our host, Dushanta. Thank you. You're on mute now, Dushanta.
Hi, okay. My turn, I guess. Thank you, David and Jeremy, for those very topical presentations and very useful guidance. I think managing projects and dealing with variations that arise from work suspensions, cost escalations, or requirements for extra time are very pertinent issues during a pandemic, which has been going on for about a year and a half now. Can I ask, would your presentation slides be made available to the Bar Association in the event they'd like to share it with the rest of the participants, the audience, or anyone else who may ask?
No problem. We're happy to do that. That's absolutely fine.
Fantastic. I would now like to call on Mr. Shanaka De Silva, President's Counsel. Shanaka, to my knowledge, has vast experience in handling high-value construction contracts, and if I'm not mistaken, he specializes in the sphere of public-private partnerships and infrastructure projects. Shanaka, can we ask you to share some insights, some experiences, and some of your practical views on today's topic?
Thank you very much, and I believe I can be heard now.
Yes, you can. Thank you.
Right. Okay. In relation to my presentation, I do not have a prepared set of slides, so I will continue to speak. In relation to my presentation, I will be dealing with three aspects. One is issues that arise when drafting and negotiating construction contracts using standard terms, then issues that arise in drafting and negotiating construction contracts without standard terms, and thirdly, issues that arise when you're dealing with disputes. So first of all, we will approach the position with regard to drafting of construction contracts, negotiating and drafting construction contracts using standard terms. Now, both the several presenters who were there before me went through certain standard form contracts, and I believe they gave a fairly good outline or overview of the provisions of standard contracts. Now, one thing that one must remember when you approach standard form contracts is the fact that these standard form contracts are usually drafted by experts. Not only are they drafted by experts, the drafts have been produced using a whole host of experiences that have been gained not only locally, but internationally in relation to implementation of contracts. And that's a vast number of contracts which are used for the purpose of gaining this experience. So therefore, when you're drafting these contracts, the standard forms, they are done to achieve a very careful balance between the various competing interests and expectations of the parties to the contract. Now, Rajendra explained the several different parties who might be involved in a construction contract. So in these standard form contracts, a very careful balance is struck between all the competing interests and all the competing, or rather involved parties in relation to a standard form contract. Now, what must be understood in relation to these contracts is that if you're entering into a standard form contract, and if at the same time you're trying to change or alter its clauses, very often what happens is you are interfering with that balance which has been struck. And that must be something which is done very carefully. Because by doing so, you are impacting various aspects. One, you might be impacting the performance of the contract. The second aspect is you might impact essentially the price at which these contracts will be performed. We might think that we are trying to reduce the price, but actually what might happen is that it might increase the price because the contractor might include a lot of contingencies into the price that he's going to bid. Because very often these standard form contracts are used not only in directly negotiated contract, but in bidding documents as well. So this is one aspect that one must keep in mind in relation to that. So when you're drafting a contract based on standard terms, the very first aspect that you must remember is how to select the appropriate set of standard terms for the relevant contract you're drafting. Now, if you look at the standard form contracts that are available internationally, there are a vast number. FIDIC is one of the most well-known. But in addition to that, you have something called JCT contracts, ACA contracts, AIA contracts, ICE contracts, NEC contracts, and so on. Some of these are British, some of these are American, some of these are European, and so on. Now, out of these, FIDIC is one of the most well-known. And in Sri Lanka, we have the ICSID type of contract. Now, if you look at even FIDIC contracts, because it is very well known, you will find that under FIDIC standard form contracts, there are a whole host of different contracts, standard forms which one could choose from. There is what is called the Green Book, which is called the short form contract. This is generally for low value contracts, like something under 500,000 US dollars. Then you have the Red Book, which is called Building and Engineering Works for works designed by the employer. So if the employer is designing the works, the Red Book applies. You have the Yellow Book, which is called Design and Build, which is for designing and building by the contractor. You have an Orange Book, which is Design and Build by and also on a turnkey basis. And then you have a Silver Book, which is called the EPC contract. That's engineering, procurement, and construction contract, usually used in construction of things like power plants and so on. Then you have documents relating to subcontracting. You have a Red Book of subcontracting, which goes with the Red Book of general conditions, and a Yellow Book of subcontracting, which goes with the yellow, that is the design build set of contracts. In addition to that, there is also what is called the Emerald Book, which deals with underground works. So first of all, when you are doing contracts on standard terms, you must select what standard term is appropriate for the job we are doing. Because if you use the wrong set of standard terms, you will find that the balance which is there in that document is not appropriate for your expectation. For example, if the engineer has designed, if the employer has designed the works that are to be constructed and you use the yellow book, you're using a wrong document, and vice versa. If you're expecting the contractor to design your works and you are using the red book is not appropriate for that purpose. So your first task should be choose the correct standard terms which are relevant. If you look at ICTAD similarly has major contracts, minor contracts, and design and build contracts. Rajendra also referred to this. So first step, choose the correct set of standard terms appropriate for you. Then we go to the next category, the next step. The next step is basically what are called the special conditions in relation to the contract. Now, if you remember Rajendra's presentation, he set out the host of documents which go into forming a construction contract. And he said there were general conditions and special conditions. General conditions essentially contain the standard form in generic form, which you can use for any contract, wherever in the world you do it. But the special conditions are those conditions which will make that general conditions tailored to suit your own contract. So this is the document by which you are tailoring the contract to suit your situation. So therefore, you need to be careful in finding out what are those issues which are relevant or necessary for you to ensure that they are tailored to your particular situation. Now, if you look at standard form contracts, for instance, if you take, for example, the FIDIC standard form, at the back of the standard form contract, you find a draft which includes those areas which you have to provide or the information which you have to provide in order to make that document tailored to your situation. In other words, there is a format which you can use for the purpose of drafting or completing your special conditions. And these special conditions are used, how shall I say, called by different names. You call it particular conditions, you call it conditions of particular application, or you might call it special conditions. So by whichever name you call, this is what you're doing. Tailor-making those general conditions to suit to your particular situation. Now, very often what happens is if you use this tailor-made form, one might think that it is very easy, it is just a question of filling certain things. But one must realize that making special conditions or tailor-making special conditions is not merely filling the blanks with suitable words. You must take care in drafting it. You can't use something that was done by somebody else for a different contract and make some simple alterations of numbers and use it for your contract. You must tailor make it to suit that particular situation. So therefore, in order to do that, you need to understand what the general conditions are, what is provided in the general conditions, what are the factual matters that are relevant to your specific contract, what are the risks involved in your specific situation, what are the measures that have to be taken for the purpose of mitigating those risks, and then you have to use that for the purpose of coming up with your special conditions. If you do not do this, you will find that there are gaps in your contract which may not fit into the exact position that you want to be in. Now, the previous two speakers, David and Jeremy, spoke about essentially variation orders and so on. And they stressed the importance of getting your documentation right in the first go. Now, if you do not do that, then only the necessity arises of getting your variation orders done. So in compiling this document, which is called the construction contract based on standard terms, it is not only the special conditions that go, but there are various other documents which are relevant, as we saw earlier. There are the drawings relevant to the particular situation. There are the specifications or the employer's requirements, as we call them in certain instances, which are relevant for that. Then there is the offer that is put out, or the BOQ. There is a response that comes, which is the tender. All these things coupled together will form the total construction contract. So when you're drafting out of this, we are now looking at what are called the special conditions. So when you're drafting the special conditions, you need to do that very carefully. You need to consider the content of the original contract. And you need to ensure that the contract is one whole and not a disjointed document. Now, very often, people also use these special conditions for the purpose of amending the general conditions or deleting provisions from general conditions and substituting new provisions. Now, you can immediately understand that that is a task which needs to be done carefully. Why? I told you right at the beginning, there is a delicate balance in all these general conditions. Now, if you do that without understanding the full impact of what you're doing and how each clause is interconnected in order to bring a complete and efficient execution of your contract, you will find that those little amendments which you do might actually create conflicting, vague, or imprecise provisions. And the moment you have that imprecision or vagueness in a contract, you're bound to end up with a dispute at the end. So whatever you do in relation to that, you need to do that carefully. Examine the provision which is there originally, see how it works in the contract document, and look at the new provision that you're trying to introduce and see how it will work in the context of the original document, the standard form. And care should be taken, therefore, not to create conflicts between special conditions and the general conditions. They need to work side by side. The third thing that you need to avoid is essentially inconsistencies between the documents that you're annexing. Now, what you need to understand is these documents which are being done and annexed to the contract very often are drafted by different people. Some of them are not even lawyers. So you have drawings which is done by someone. You have BOQs which are prepared by another person, specifications prepared by a third person, employers' requirements probably done by another party. And then you have the standard terms, which are the general conditions, and the special conditions, which are done by two different entities. In such instances, it is very often you will see that these documents will conflict with each other. Sometimes in the manner in which they communicate things. You might be trying to communicate the same idea, but it might be expressed in different vague words. And when you take them in sequence, you might find that the meaning is not quite clear. So when you're putting together this set of documents, it is necessary for you to ensure that all the documents, right from the drawings until the general conditions, talk the same language. If not, they become imprecise, unclear, vague, and the result might be a dispute. And this is where the function of lawyers comes. That is why lawyers need to be involved in the drafting of these construction contracts. That is why it is necessary for lawyers to be very, very closely involved in drafting special conditions. So bringing about the whole of this contract together essentially is a work for a lawyer. I'm not saying that there aren't others who do a very good job. There are. You get architects who do this. You get engineers who do this. But lawyers are ideally suited to do this kind of ensuring the consistency amongst all documents and putting the drafts in order. The other aspect that one has to look at is a list of priorities among the documents. Now, Rajendra listed out a whole series of documents. Now, in case of an inconsistency, what is it that prevails? What should be the controlling document? Should general conditions prevail over the special conditions, or should special conditions prevail over the general conditions? Common sense dictates that special conditions should prevail over the general conditions. Not only in relation to these two, but you will find that there are other documents as well. You have the drawings, you have the specifications or employer's requirements, you have the tender which goes out, and you have the response that is given, which is the bid or the tender supplied. So all these things have to be put together and become one contract. So in that context, you must pay attention to what the priority of documents needs to be. So those are my observations in relation to issues of putting together a contract using standard terms. Then we go into the second aspect, which deals with drafting contracts which are not on standard terms. Now, if you're drafting a contract which is not on standard terms, you will find that you have to pay attention to all the aspects that were spoken of, from essentially performing the basic functions and going right down to the issues of drafting all the aspects relating to force majeure, change in law, variation orders, priorities, and so on. Not an easy exercise to do. All the involvement of everybody else. So I think it is not a task which is to be carelessly undertaken. Give a lot of thought to it before you do that. So if you're doing that and you decide to do that, understand the project, understand the responsibilities of each party, understand the risks that have to be faced by each party, and then only you should go on to draft the document. Then I'm going on to discuss or deal with very briefly issues in dealing with disputes relating to construction contracts. Very often disputes arise in relation to delays, claims for extension of time, and liquidated damages. Extra works and contracts, variation orders, and defective works, and so on. Now, there are contractual provisions dealing with these. And I think it is necessary for you to look at those contractual provisions and make your claims appropriate. Now, one aspect that I would like to pay attention to very simply is essentially the fact relating to dispute adjudication boards. In many of these contracts, you have provisions dealing with dispute adjudication boards. Sometimes we're not very familiar with that. There are advantages and disadvantages of this. What are they? These are simple processes of putting or settling a dispute. Now, the advantage is it is very quick to do this, it is very cheap to do this, and it is generally done by industry specialists. So you can go to them and get a quick result from them. On the other hand, there are certain disadvantages arising from them as well. One disadvantage is essentially that there is no mechanism for enforcement of these. As a result of that, it is left to the parties voluntarily to comply with that. And if they don't comply, you have to go into formal dispute resolution processes. So in that context, one needs to consider whether it is appropriate to have dispute resolution, dispute adjudication boards or not. Some people don't like it, some like it. Very often in large construction contracts, they play a very big role in ensuring that quick action is taken so that the contract can go on smoothly. So therefore, this is one aspect you must make yourself familiar with and perhaps look at carefully in introducing to contracts. So because of the constraints of time, I will pause there and hand the situation over to Dushanta. Thank you.
Thank you very much for your views and insights, Shanak, and I think I add very well put. We will now move on to the second part of this webinar, which is the Q&A session. We have received several questions from the audience, some early on during the day as well, which I would like to pose to the panelists. Of course, time constraints may make it very difficult to run through all of them. We will try to finish, and I will ask the assistance of the panelists to try to get through some of these questions as soon as possible. My first question that we have received is posed to Rajendra. Rajendra, when entering into construction contracts, is it mandatory to follow standard agreements published by recognized institutions or authorities set up for construction related matters? And I think the reference here is to CEDA.
That's a good question, Dushant, because CEDA specifies that one has to use the standard documents, as the standard building documents, if they are entering into identified construction work. So yes, in Sri Lanka, we'll have to adhere to that. But as to whether they monitor it properly is another question. But the direct answer is yes, they have to.
Thank you. So basically, I mean, if they fall as identified projects, they're within the CEDA definition, Act definition, they need to follow the standard bidding forms and the other documents.
Yes.
Thank you. My second question is to Jeremy. Should the project manager's contract and main principal contractor's contract correspond or link with each other? And I'm assuming the reference here to project manager's contract is perhaps to the engineer's contract, but I could be wrong.
Yeah, look, I was thinking the same, and I've kind of approached it that way. I don't think they should normally link to each other because they're typically separate documents. You would generally have one contract between the employer and the engineer, and then you would have the contract between the employer and the contractor. Now, the contract between the employer and the contractor will specify a number of functions that the engineer needs to undertake on behalf of the employer. And for that reason, it's critical that the contract between the employer and the engineer provides for those powers as well and how they're to be done. And so they need to correspond. Yes, they need to see eye to eye effectively, and you need to ensure that the same powers are given to the engineer, at least the same powers are given to the engineer in the contract with him as there is in the contract between the contractor and the employer. But typically you wouldn't wrap it up into just one contract, because then you end up with a tripartite type agreement. And frankly, there's a lot of things from a commercial perspective that you might not want the other parties knowing what's in the agreement. If you're the employer, you may well not want your contractor knowing what you're paying your engineer for various things. But certainly there does need to be some alignment, because you as the employer are going to be responsible to the contractor for what the engineer does. So if the engineer breaches the contract or his obligations under the contract between the employer and the contractor, the employer is the one who's going to have to accept responsibility for that and then try to recover from the engineer separately. So there needs to be some alignment.
Thanks a lot, Jeremy. No, I think that answers it. And that goes, I guess, to the heart of your discussion on variations and authority for those. My next question is to David. David, what are the key points that should be considered for liquidated damages? And this is a question coming from one of the audience members early on today.
Yeah, thank you for that. So you could do a whole webinar on liquidated damages by themselves. But in the interest of time, very briefly, I would say when you first are looking at a contract and entering into a project, certainly liquidated damages is something you need to really think about and consider the clauses of the contract in detail. So things I would be looking at are, does the clause provide that LDs are exhaustive, meaning they're the only remedy available for delay? Is there a cap on LDs? So what is the maximum the contractor can incur in terms of liquidated damages? Are there any specific carve-outs for LDs from the maximum liability under the contract? Are there any provisions that specifically provide for LDs still being available after termination of the contractor, which is a big issue? Are there any elements of LD's clause that are uncertain? You see some very badly drafted liquidated damages clauses, so we need to make sure it works on a very basic level. Looking at whether it's a penalty clause, which in some jurisdictions are not allowed, such that the LD's clause would again fall apart and not be operable. And what is the position in terms of if there's any sectional completion or if the employer is taking early possession? What do the LD's provisions say about those as well? I hope that's helpful.
Absolutely. No, that was very, very helpful. Shanaka, this question is to you. What are the key points to be considered in terms of dispute resolution? Would you consider arbitration to be a better option than courts? And I perhaps think that this is a more very, very local issue, given the peculiarities of our own dispute resolution fora.
Yeah, okay. In a construction contract, I think what is essentially required is very fast resolutions when the contract is ongoing. So therefore, one must be able to go and get a quick decision. So it is in that context that I spoke of the dispute adjudication board as opposed to arbitration and mediation. That is really a pre-step to going to arbitration or to courts. So one method that you can look at is quick, cheap resolution of disputes, or at least an opinion given as to what needs to happen so that the parties can at least accept it and go forward if they wish to. So that is one aspect. The second, because always one must remember there is a time for completion. And if disputes stop that, your contract stops. So both parties suffer as a result of that. Then with regard to arbitration and litigation. Litigation, we all know, we go to court, we file our claims, we wait for our turn in court. Court has 20 other cases in addition to your case. The judge is not a construction expert. He is a judge. So therefore, your dispute will take very long to finish. Now, if you, on the other hand, you go before an arbitration panel, you can select the arbitrators you like. They can be experts in your field. They need not be lawyers or judges. They could be engineers. And I've sat with engineers who are very, very good arbitrators in construction contracts. And in those situations, they understand what you're talking about. It is a dedicated forum. Of course, it is more expensive than going to court because you have to pay for the center as well as the arbitrators when you're having an arbitration, but yet your matter will get full attention because that's the only matter they're dealing with. And if you manage your position and the parties want a quick resolution, the parties can achieve a quick resolution. Of course, if one party is non-cooperative, then there are secondary aspects that arise where the tribunal has to interfere. But I would, in a construction contract, advocate arbitration over litigation.
Thank you very much for that very decisive answer. The next question that we have, and it's a two-part question, comes with a little bit of an explanation as well. And I'll read it out because the context is quite pertinent. Dear sirs, the housing construction companies normally produce their own standard forms of contracts to the customers. Most of them are not according to ICTAD format. And they also offer lump sum price to build the house. At these moments, construction companies do not prepare BOQs to subsequently, when they face difficulties, they give up the constructions. Customers find completed construction 2 has defects. In these contracts, dispute resolution clause 2 is available, which indicates any dispute first to be settled amicably, then with the mediator, and finally with arbitration. My first question: what is the mediation process to the customer allowed? Is the customer allowed representation by attorney at law, and how this mediation differs with arbitration? My second question is, can the customer continue with the construction contract without prejudice to the action taken against the former contractor? So the first question, is this mediation process by the customer permitted to have an attorney at law representing that customer? And how does the mediation differ from arbitration? May I ask whether one of our panelists, local, could take the question? Who would like to answer?
Yeah, I will perhaps answer that. Okay, if you look at arbitration, arbitration is basically conducting your case in an adversarial setting outside of court. So you have a panel of arbitrators or tribunal sitting, and they listen to the two parties and they give an award. So you call witnesses, there is cross-examination very often, may not be, but very often, and re-examination, and then written submissions, and the whole works generally, and then an award is given. So it is essentially an adversarial setup which happens outside of court. On the other hand, mediation is very different. Mediation is where there is an independent party whom the two disputing parties agree upon, and this independent party facilitates the two disputing parties to arrive at an amicable settlement of the dispute. So it's a facilitation process that the mediator does. He will mediate with the parties and try to encourage the parties to settle the matter. Now, in a typical mediation, once you start the process, the mediator will speak to each side individually and get the two versions, discuss with the other party about the merits and demerits of each party's case, and then show them, look, there is another side to your issue. And all this is done very amicably, not in an adversarial manner. And once it develops to a situation where the two parties can meet, the two parties will then meet and take it forward. So in that context, one might think that it is not really necessary to have a lawyer present. But I have always found that parties like to be represented by lawyers, even in a mediation. Merits and demerits of that are there. But as to whether lawyers can participate or not depends on the mediation rules you are binding yourselves to. So the mediation rules will say that the parties can be represented by lawyers or not. Because this is a process that you are doing. On the other hand, just as much as you can change your arbitration rules by agreement, it might also be possible for you to change your mediation rules by agreement. So by consent of parties, it might be possible for both parties to be represented by lawyers or decide not to bring them in. As to the prudence of deciding to include lawyers or not, I think the parties really have to consider that. I hope my answer is clear.
Very, very, very well put. Thank you, Shanaka. So the second part question of that question is, can the customer continue the construction without prejudice to the action being taken against the former contractor? Perhaps would Rajendra, would you like to take this question?
Yes, Dushanta. If you look at it, the customer will have no contract with the contractor, because the employer will have the contract with the contractor, building contract as the building construction agreement. So if the customer's rights would depend, because the customer will go and purchase that, we are necessarily talking of an apartment complex and an apartment. right? So the customer would necessarily go and buy his unit from the employer. And the employer, I would say, will promise an apartment which is livable. So if the employer doesn't provide an apartment which is livable, then the customer's remedy will be against the employer. Coming back to the construction part of it, it will all depend on I'm sure he can go ahead, because if it's not in a livable condition, he can spend his money and repair and bring it up to that standard, but his remedy will be against the employer or the person who sold the apartment and not against the contractor. I don't know whether I made myself clear or whether I understood the question clearly. I'm not too sure, Dushanta.
No, I think you answered it well, but I have one question. What about now? It's very common in the local market for small-time SME contractors to become developer contractors and offer, for instance, these smaller houses within, let's say, a 30-40 perch block, where they build it and give it to you. And that agreement that you have with that developer contractor is effectively your construction contract, perhaps. Now, these contracts are also not governed as we learned earlier. They may not fall as identified projects. In those circumstances, obviously the rights and remedies are in terms of whatever contract you signed, however badly it is being drafted, however one-sided it has been drafted. Do we have any recourse in Sri Lanka? Now, CEDA requires particular contracts, as all our panelists mentioned, SPD, FIDIC, all those rules are by and large fair and reasonably drafted. But when you have these kind of contracts, obviously lawyers get involved and try to protect, but you are working with whatever document has been signed. What are the views of our panelists? And it's open to all panelists, and I would like to also get our views from our international panelists as to how it's handled in other jurisdictions. But any views on this? Shanaka,
okay.
Rajendra?
Okay, so I'll go first until then before Mr. De Silva. So I would think in a scenario that the example that you gave, Dushanta, is where a small timer gets a contractor to build on his land.
Absolutely.
Right? So most of the time, practically, although CEDA requires has set out certain guidelines and set out certain statutory regulations, they don't follow it, right? So the remedy, in my view, that the owner of the land has is based on the contract with the contractor, because the owner, having not followed CEDA, cannot go and complain to CEDA, right? So his remedy will lie on the contract he has with the contractor. That's my understanding.
Thank you. Shanaka, Jeremy, David, do you have any views on this?
Yeah, can I just say two things? I think CEDA, there is a mediation and a conciliation function, which they do perform. And the word used is construction work, as opposed to identified construction work. So in that context, that seems to be a little wider. So one might be able to say that such construction disputes can go there, right? But I think the wider issue is the fact that we don't really have basic standards relating to construction issues in minor construction work. So therefore, this kind of situations arise. I think even in your previous answer, previous question that was asked, there was a question about, condominium properties and residential properties, which are done on lump sum contracts and so on, right? So those happen because there are no standards, construction standards, which are generally applicable, which you have to comply with. Not a very satisfactory situation, because people go and live in these, even condominiums, right? So in that context, I think the time has come for us to look at incorporating standards of this nature and make sure that all construction complies with that. So.
Thank you, Shanaka. David, can I quickly, because we've got to wrap this up now and I have to hand over to Ma, can you, there was a question about what kind of books you can recommend for construction contract, for practitioners to get a better understanding. Could you quickly perhaps mention some books you can recommend?
Yeah, absolutely. So ones that I refer to in my practice are Keating on construction contracts, Hudson's building and engineering contracts, Wilmot Smith on construction contracts, and Niall Bunny's book on the 1999 FIDIC Rainbow Suite, which is also very good. I would also say that to keep updated with regular news, law firms, I know CMS does, we've got a facility called Law Now, which you can subscribe to, and you'll get updates on all the relevant construction law. So I would encourage people to sign up to that sort of service as well.
Thanks a lot, David. I must apologize to our audience. There's a lot of questions that we have not answered. What I will try to do is I will collate them with the assistance of Uma and the Bar Association, and we will send them over to the panelists, and when they get time, they will answer and we will get it back to you. I'd be grateful because all these questions are from anonymous or people whose emails are not there. If you can email them, that might be much easier. I want to take this opportunity to thank our panelists for their valuable time on this. I know it was put together not so long ago, and to take time off on this Saturday to participate is very much appreciated. Thank you to the Bar Association for putting this together and the webinar series. And in particular, Rajiv Amarsurya, the secretary, as well as Anne, Nikini, Uma, all of those who helped get the panelists organized and put together this webinar. Finally, thank you to our audience for participating. Again, one last apology for not answering the questions. We'll get to those at some point. Have a good evening. Thank you. Over to you, Uma.
You're on mute, Uma.
Hello. Yes, I hope everybody can hear me. Thank you, Dushanta, for assisting us in today's webinar. And as you correctly said, we will do our very best to get the answers to the members of the audience who did post questions. And that being said, I guess we have to wrap up today's webinar. I'm sure all participants gained a whole lot of insight regarding negotiating and executing construction contracts. I'm glad we had so many participants joining in and interacting today with a lot of questions coming in. I also wish to thank our panel of speakers, that is Mr. Mr. Chanaka De Silva, Mr. Jeremy Witt, Mr. Rajendra Jayasinghe, Mr. David Wright, and Mr. Dushanta Pereira. We really appreciate you taking time off your busy schedule on a Saturday evening and making a valuable contribution to today's discussion. I would also like to thank the management committee and the seminars committee and all those who helped in numerous ways to make this webinar fruitful. Thank you all for joining. I hope all of you have a pleasant evening. Stay safe. Good night.